Today, we're talking about family immigration and marriage-based green cards, how they work, who qualifies, and what couples need to know before starting the process. Before we begin, it's important to mention that this webcast does not constitute legal advice. It's only for informational and educational purposes. I'm Mark Hirsch, a non-attorney spokesperson. Today, I'm joined by Fritz Polacek, managing attorney at Polacek, Bohm, and Wilkowski. Fritz has over 30 years of experience helping individuals and families navigate U.S. immigration law, including marriage-based green cards. So glad you could join us, Fritz.
My pleasure.
Wonderful. Fritz, let's get started with the basics. We have a question from a U.S. citizen married to a foreign national. In simple terms, what applications do they need to file for a marriage-based green card?
Well, if we are applying for the green card in the United States, there are two places to do it. You can do it abroad, which is called visa processing, or you can do it in the United States, which is called adjustment of status, depending on your circumstances. So assuming we're doing this in the United States, there'll be four basic applications. The first is an immigrant visa petition, which is filed by the U.S. citizen. In effect, it states, I'm a U.S. citizen, I was eligible to marry, I married the foreign national, approve our marriage so he can have an immigrant visa number. The second application is an adjustment of status request, and that's filed by the alien. That's a form which has biographic information about the alien and a series of questions which are designed to determine if they're inadmissible to the United States. Things like if they have an arrest record, they've been involved with terrorism, hijacking, espionage, things like that. The third application, and that schedules the couple for an interview here in the U.S. The third application they can file is a request for a work permit, so the alien can get Social Security and a driver's license and a work permit while they're waiting for their interview. And the fourth application they can file is a request for an advance parole, which in English means a travel permit, so that they can travel in and out of the U.S. while the application is pending. If they leave the United States without the advance parole, the applications are deemed denied. So those are the four basic applications that are filed simultaneously if you're processing in the United States through a marriage case.
So that's the core process. Now, one point that often confuses people, does it matter if the marriage took place outside of the United States, or are foreign marriages also recognized for green card purposes?
That's a good question. It doesn't really matter where you're married, provided you are married in accordance with the laws of the jurisdiction where the marriage took place. So if you're married in Turkey, let's say, if the marriage is valid in Turkey, that would show up on the marriage certificate and that would be recognized by the United States.
And another foundational question that I know we see in a lot of cases, if someone was previously married, what documentation is required to prove that those marriages were legally ended? And does the country of divorce matter?
It can. Of course, you can't be married to two people at the same time. So you have to demonstrate that you were eligible to marry. And that's done either through a death certificate or a divorce judgment or an annulment. Some countries have jurisdictional requirements that are different from the United States in order to get divorced. For example, it may be required that both parties are physically present in the country where the divorce judgment was issued, or that they're domiciled there. And so that can be a little bit tricky. So you have to be there. The Foreign Affairs Manual, which is issued by the State Department, sets forth the requirements for the divorce. As long as the document comports with that, you should be okay.
Okay. And if a U.S. citizen marries someone who has children, can those children also qualify for green cards, and under what conditions?
Okay, so if the foreign national's children are under 18 at the time the foreign national and the U.S. citizen marry, the U.S. citizen can petition for the children as though they were his or her children. But they have to be under the age of 18 at the time of the marriage. Otherwise, once the alien gets a green card, they can file a separate application in their own name for the children. But that application has time constraints on it. It can take a while for it to be approved. So there may be a period of separation between the parties.
And one of the biggest concerns that people search for is prior immigration issues. So if someone overstayed a visa before marrying a US citizen, can they still apply for a green card from inside the USA?
Yes, but there are issues of removability.
Hmm.
There's a concept known as unlawful presence, which is different from the concept of being out of status. You can be out of status for any number of reasons. You can work without permission. You can overstay your visa. But if you're accumulating unlawful presence, which is measured typically by the expiration date of your lawful stay in the United States, that can be a very big issue, which could bar you, if you're going to be visa processing, from getting a green card without a waiver. Because if you accumulate over 6 months of unlawful presence and you depart the US for any reason before you have a green card, even if you're going for an interview to pick up your green card, you'll be denied and you'll be barred from re-entering the US for a period of 3 years. If the unlawful presence is over a year, you're barred from re-entering for 10 years. That can be a very big issue if you overstay. Typically, if you're married to a US citizen and you've overstayed or you've worked without permission, there is essentially a forgiveness for that if you're doing it in the United States.
And closely related to that, does unauthorized employment, working without permission, affect eligibility for marriage based green cards?
That's a good question. The answer is, as a practical matter, no. So if you work without permission in the United States, you're removable. You can be what we used to call deported for working without permission, even if it's only one day. If you overstay, even for only one day, again, you're out of status and you can be removed from the United States. If you marry a US citizen, the I-45, that adjustment of status application we talked about earlier, has a question and asks you, did you ever work without authorization? Did you ever violate the terms of your non-immigrant status? And you would have to answer those questions truthfully and say yes. Once you do that, you have acknowledged that you are removable from the United States. So technically, you could be removed, and you've admitted it on the application. But as a practical matter, as long as you tell the truth about it, once the application is filed, you're put in what is called lawful stay. It's a technical term. It's not the same as being in lawful status. And that permits the Immigration Service to adjudicate the 4 applications we talked about earlier and to permit you to get your green card. There have been some overzealous activities by ICE, which got a lot of press, where people were picked up at interviews because they acknowledged that they were out of status or worked without permission. And but those cases were resolved relatively quickly, because the alternative would be they'd be placed in removal proceedings and they'd be eligible to get their green cards in front of the judge. So why would ICE do something like that? As a practical matter, it shouldn't be a bar.
Now, let's talk about where the process actually happens. What's the difference between applying for a green card through adjustment of status in the US versus consular processing at a US embassy?
So in response to your first question, I explained the applications that are all filed simultaneously here. If you're going to visa process and you're going to have the interview abroad, let's say your spouse as an immediate relative and your spouse or your children are in your home country, don't have visas to get into the United States. We filed just the I-130, the immigrant visa petition by the US citizen, requesting the visa number. You can think of it that way. And then when that's approved, it's sent to the National Visa Center, which is a processing facility in New Hampshire. Then you apply through the National Visa Center online with documentation, and you're responding to all the questions you would do with the adjustment of status. When the National Visa Center sees that your application is documentarily complete, they forward it to the embassy, and an interview is scheduled at the embassy. Now, the difference is timing. It can take a little while, and you'll be separated from your family while it's going on. And the US citizen is not present at the interview. So there's no inquiry about the bona fides of the marriage, let's say, that the US citizen would have to respond to. The alien is the one who would answer those kinds of questions. Typically, they're done with documents. So you go for the interview abroad. The processing time can take well over a year before that gets completed. And it's, as I said, a two-step process. First USCIS and then the National Visa Center, which schedules your interview abroad.
Not every case involves a US citizen. So, how does the process change if someone is married to a green card holder instead of a US citizen?
It presents a number of issues. The first is when you file the immigrant visa petition as a green card holder, you're considered a preference case as opposed to an immediate relative case. An immediate relative would be a marriage to a US citizen. Preference cases are assigned a priority date when the application is filed. So you file the I-130, you're assigned your priority date. A priority date is a little bit like going to the bakery. You get a number and you wait for the number to be called before you go up and buy your donuts or your bread. So you have to wait in line. Every month, the State Department issues a bulletin called the Visa Bulletin, which tells people where their priority dates in the various lines that are in the bulletin. One of those lines is a preference case for a green card holder filing for a spouse. And when that number becomes current, reaches the top of the list, then you can apply through the National Visa Center for your interview, or if you've been in status every minute, you can apply for adjustment of status. So that's always a challenge as to whether or not the alien can remain in status, which they must do as a preference case. Remember, we talked about being forgiven for working without permission or overstaying if you're married to a US citizen. If you're married to an alien, you have to have a clean record every minute. So that can be a consideration because you want to be careful about unlawful presence.
Well, let's zoom out for a moment, Fritz, because beyond eligibility, there are a few things that really determine whether a case goes smoothly. So, what are the most common mistakes that couples make when they're applying for marriage-based green cards?
I don't mean to sound self-serving, but the most common mistake is not seeking adequate advice before they file. It's always a good idea to speak to an immigration attorney who has some experience in this. There can be many pitfalls. The unlawful presence issue can come up. There could be criminal matters which require waivers. If they've been in proceedings, they could be barred from filing. So they file only to discover at the interview that they filed improperly and they're not eligible to get their green card through USCIS. There are a multitude of issues that can come up. I can't give you an exhaustive number of them, but all of them can be addressed. If at the beginning, after you say I do, or even before you say I do, you seek advice of competent immigration counsel.
That makes sense. And one of the most important parts of the process, how does the USCIS determine whether a marriage is bona fide, and what evidence should couples provide to prove that they have a real relationship?
Okay, so one of the things, of course, you have to prove that you're in a valid, real marital relationship or a bona fide relationship.
Right. Oh.
The Immigration Service tests this in two ways. One is by looking at documents and papers that married people tend to collect over time. But everybody's marriage is different, so everybody has different documents. We have a list of suggested documents that clients can start collecting well before the interview. There are two kinds of people who keep paper and people who throw paper away, and we train them to be people who keep paper. The second way they test, and that those documents are presented to the officer at the interview, and some of them are actually presented with the immigrant visa petition. The officer will review the documents, and the second way is by talking to the alien and the spouse. You can have a long interview or a short interview. In the short interview, the questions are relatively simple. How did you meet? Who was at your wedding? Did you exchange wedding rings? In the long interview, which doesn't happen all the time, but it can, the couple is separated. And they ask the wife some questions and they ask the husband some questions. There are no right answers. There are no wrong answers. They don't care what your answers are by and large. You have to have the same answers. Now, it's been my experience that husbands are typically wrong and can't remember things. Now, that's not always the case, but it would be the case in my situation. So we have the clients come to us and we do a thorough preparation by asking them all these questions. We don't tell them what to say, but memory is a funny thing and we help them harmonize their recollections of things. But that's how they test the bona fides of the marriage.
And timing is certainly another big factor. So, What is the typical timeline for a marriage-based green card, and what factors can cause delays?
Okay, so the timeline is difficult to say. It's somewhat elastic. There are periods when it's really quick, 4 months. There are periods when it can take well over a year. We don't have control over that. It has a lot to do with the allocation of resources by USCIS. You can speed up the process by having a completed application that's properly filled out initially. If there's an issue with the application, the wrong box is checked or the data is incomplete, you'll get from the Immigration Service something called a request for additional evidence. Then you have time to respond to that. Of course, that can slow down the process. Right now in South Florida, for adjustment of status cases that are processed in the US, it's taking about 6 months, 4 to 6 months. Visa processing can take, consular processing can take well over a year.
And during that waiting period, can applicants legally stay in the United States and work while the green card is still pending?
They're authorized to work when the employment authorization document is issued. Typically, that takes around 6 weeks, and then they're authorized to work. Of course, it lets them get a social security number and a driver's license and have a fairly normal life. But they're not authorized to work until they get that document. They're in lawful stay. So they shouldn't be looking over their shoulder worrying that they could get picked up if they had been out of status in the past. As long as they carry those receipts, the Immigration Service is likely to leave them alone and let them complete the process through USCIS.
And looking a bit further ahead into the future, what happens after a marriage-based green card is approved? Are there conditions for follow-up or any requirements that couples should know about?
That's a good question. If on the date of approval, the couple is married less than 2 years, they'll receive a conditional resident card valid for 2 years. 3 months before that card expires, there's that 90-day window. They are required to file an application to remove conditions or have their green card converted into a 10-year green card. Now, the government's worried about marriage fraud, and so you collect documentation to demonstrate what you've been doing since you got the green card, the first green card. And then that application is filed. If you have a lot of documentation, you're likely to be approved in the mail. If you're divorced, you can still file, but you're more likely to have an interview and explain what happened. And you present documentation to demonstrate you were with your spouse for as long a period of time as you were together. And then after that, you can apply for US citizenship. The US citizenship track is 5 years typically, hold a green card for 5 years. But if you've done it through a marriage case and you've been married 3 years to a US citizen and you've had a green card for 3 years, you can file for citizenship under that rule, under the 3-year rule. Both of those applications can be actually filed 3 months before either the 5-year anniversary or the 3-year anniversary.
And to bring this all together in a practical way, Fritz, if you had to give couples one piece of advice before they start the process, what would it be to give them the best chance of success?
I would say you have to be able to stand in front of your parents and tell them that this is the person I want to spend the rest of my life with. That's going to inform everyone as to the validity of your marriage and your actual intentions, which are true and accurate. That's really the biggest thing. The other documentary stuff and the other regulatory stuff that we have to deal with, that can be reviewed with the attorney at the very beginning, and those hurdles can be addressed. But fundamentally, the marriage has to be a real marriage entered into for all the right reasons.
Well, Fritz, this has been incredibly helpful. If somebody is watching this and thinking about applying for a marriage-based green card, what's the best next step for them?
Well, I would say, as I said before, speak to competent counsel before you get married, because issues can come up if you marry too soon after you enter the United States with respect to your intention when you last entered. It's a good idea before you get married to speak to counsel. Of course, if you're already married, talk to somebody who knows what they're doing before you file. A lot of people go to notary publics thinking that a notary is knowledgeable enough to do this, or they'll tell you it's just a question of filling in forms. You don't really have to pay the money for a lawyer or to consult with a lawyer. That is completely untrue. and can get you into a lot of trouble. A notary public cannot help you if you get a request for additional evidence, or if there are questions that arise at the interview. You have to have someone who's admitted to practice law. So I would say that's the most important thing.
Great. Well, Fritz, thank you so much. Really appreciate the time.
It's my pleasure.